Case 1, Aaliyah Jack. July 8, 2024. Calcasieu Parish, Louisiana. Some stories arrive without warning. They come out of the middle of an ordinary summer day, wrapped in heat and silence, and they leave marks on a community that never fully heal. The story of legendary Jack is one of those stories, a story about a little boy who deserved everything and received almost nothing, about a brother who survived when he should not have, and about the questions that linger in the air above a welcome center on the Louisiana-Texas border like something that can never quite be answered. It was the 8th day of July, 2024. Tropical Storm Beryl was making its presence known across southwest Louisiana, pushing bands of wind and rain inland as the Gulf Coast did what it has always done, absorbed the storm and kept moving. Interstate 10, the long ribbon of highway connecting Louisiana to Texas, was still carrying traffic. Truckers, travelers, families in their vehicles passing the Welcome Center at Vinton, the last official stop before the state line, maybe pausing to stretch their legs, maybe not pausing at all. Someone paused that morning. A passerby noticed something in the water behind the Louisiana Welcome Center, something that did not belong in that place, that was not part of the landscape of the rest stop, the flagpoles, the brochure racks inside the building. What that person saw, and what they reported to the Calcasieu Parish Sheriff's Office, set in motion one of the most heartbreaking investigations Southwest Louisiana had ever seen. Deputies responded to the Welcome Center and discovered the body of a young child in the body of water located behind the building. The child was a boy. He was 4 years old. He showed no obvious external signs of what had caused him to end up in that water, and an autopsy would be required before investigators could speak definitively to the circumstances of his passing. His identity was not immediately known, but the case was already being treated with the full weight of a major criminal investigation. The Calcasieu Parish Sheriff's Office, led by Sheriff Gary Stitch Guillory, moved quickly. Investigators began working to identify the child and to understand how he had come to be in that water, at that place, on that morning. Through careful investigative work and the assistance of family members who came forward with information, the boy was identified as Legendary Jack, a 4-year-old from Lake Charles, Louisiana. And Legend had not been alone. When investigators pieced together the timeline, they realized that Legend had last been seen with his mother, 25-year-old Aaliyah Jack of Lake Charles, and his 1-year-old half-brother, King Trail. Legend's paternal grandmother, Dion Polk, came forward and told authorities that the boy had actually been living with her since May, that his mother had essentially handed him over to her, telling the family she wanted to, in her own words, live her best life. On July 6th, Legend had been dropped off with his maternal grandmother for a funeral. That was when Aaliyah Jack had taken both boys and disappeared. Legend called his mother Aaliyah. He never called her mom. That detail, offered quietly by his grandmother to the American press in the days following his death, says more about the reality of that child's life than almost anything else in this case. As investigators began searching for Aaliyah Jack, a second fear was taking hold. Where was King Trail, the 1-year-old? If Legend had been found in the water behind the Welcome Center, what had happened to the baby? The answer came on the morning of July 9th, a full 2 days after Legend's body had been discovered, 2 days during which Tropical Storm Beryl had pushed its outer bands across southwest Louisiana with heavy rain and dangerous conditions, 2 days during which a 1-year-old child was somewhere along the side of Interstate 10. A truck driver, traveling east on Interstate 10 near mile marker 10, saw something moving in the drainage ditch alongside the highway. He stopped. He looked again. And what he found? A baby, crawling toward the highway, covered in insect bites, wearing only a diaper, stopped him completely. The driver called 911. Within minutes, emergency responders were on scene. The 1-year-old King Trail was alive. He had survived 2 days and 2 nights of tropical storm conditions alongside an interstate highway. He had insect bites across his small body. He was sitting up in the ambulance. He was drinking water. Sheriff Guillory, visibly moved when he addressed reporters at a press conference, spoke a single phrase that defined the boy from that moment forward. "We look at this 1-year-old as our miracle baby," the sheriff said, because he was still alive. Unbelievable. The miracle baby. He had crawled toward the highway when investigators reviewed security and doorbell camera footage. He had been out there, in the storm and the heat, since the moment his mother had left him. And he had survived. Aaliyah Jack had not gone far. On the night of July 8th, the same night Legend's body was found, investigators had already connected the case to her identity and issued a warrant for her arrest. Law enforcement agencies across the region were alerted. She was located at a train station in Meridian, Mississippi, preparing to board a train. The Meridian Police Department took her into custody. She was extradited to Louisiana on July 20th, and that is when the cameras captured her. As she walked toward the entrance of the Calcasieu Correctional Center, a KPLC reporter asked her directly what had happened to her children. Her answer was brief. "I had did that to them," she said. She had been under the influence of controlled substances. She was not sure why she had left the baby on the interstate. Those words, spoken on camera while walking into a Louisiana jail, became the centerpiece of a legal controversy that would extend into 2026. Aaliyah Jack's defense team would later move to have that on-camera statement suppressed, arguing that the circumstances under which it was obtained were improper. As of April 2026, that legal battle was still ongoing in Calcasieu Parish Court. The charges against Aaliyah Jack are serious and extensive. She faces one count of second-degree murder in connection with the passing of 4-year-old legendary Jack. She faces one count of cruelty to a juvenile in connection with the treatment of King Trail. And she faces 2 counts of failure to report a missing child, a charge that speaks to the hours during which both boys were unaccounted for and no report had been made to any authority. Her bond was set at $9,100,000. She remains in custody. The paternal grandmother, Dion Polk, gave an interview that no family member should ever have to give. She spoke about what Legend was like. Loving, smart, curious. She talked about the things they did together, riding around town, taking vacations, talking, playing games, shooting water guns at each other. She spoke about the last time she saw him, a little boy who yelled out, "No, I don't want to go with Aaliyah," as he was taken from her. A little boy who had never once called his own mother Mom. "I want the people to know that Legend has a family that loved him with everything they had," she told the American press. "I have never in my life felt pain like this. Never. It's like I'm outside of my body." The maternal grandmother, Consuela, described the Sunday before the tragedy, July 7th, when her daughter sent her a photograph of a vehicle that appeared to have been in some kind of accident. She called repeatedly. No answer. One message came back. And then silence. Legend's bond was set at $9,100,000. A 4-year-old boy loved by his grandmothers, loved by the family that had been raising him, lost in the water behind a welcome center on the Louisiana-Texas border while the storm came in off the Gulf. He was 4 years old. The miracle baby, King Trail, was transferred to the care of the Louisiana Department of Children and Family Services following his rescue. He survived. He is alive. And investigators, the community, and the people of Southwest Louisiana hold on to that fact as the one piece of this story that provides something other than grief. This case has sparked important conversations in Louisiana about child welfare oversight, about the systems that are designed to catch situations before they reach a point of no return, about what support structures exist for children whose caregivers are struggling with controlled substance dependency. Those conversations are continuing. The legal proceedings are continuing. And legendary Jack, a little boy who deserved every single day he was robbed of, is not forgotten. When a child's life is cut short, the community must demand accountability. The courts must deliver justice. And every one of us who hears this story carries a responsibility to advocate for the children who cannot advocate for themselves. We honor Legend by speaking his name, by remembering him, and by refusing to look away from the hard questions this case demands we answer. If you know a child in an unsafe situation, please reach out to the Child Help National Child Abuse Hotline at 1-800-422-4453. You could save a life. If this case moved you, if Legend's story matters to you, don't forget to like this video and subscribe to Cold Case Hour. Every subscriber tells YouTube that this kind of serious, responsible true crime documentary deserves to be seen. We'll continue bringing these stories to light as long as you're with us. Case 2. Madelyn Abisai Mejia-Gallo. March 23, 2022. Orleans Parish, Louisiana. The north shore of Lake Pontchartrain sits just across the water from New Orleans, close enough that families cross the Causeway Bridge for work, for school, for medical appointments, for the kind of everyday movement that connects communities. On March 23, 2022, A young mother made a trip from the North Shore to a hospital on that side of the lake, carrying her 6-month-old son. The child had injuries to his head that the medical staff who received him immediately identified as severe. What happened next, and what investigators ultimately concluded had happened before that hospital visit, became the foundation of a second-degree murder case that underscores one of the most urgent child protection conversations in the country. Madelyn Abisai Mejia-Gallo brought her infant son to the North Shore Hospital on that March morning. The child was 6 months old, barely past the fragile newborn stage, not yet able to sit unsupported, entirely dependent on the adults in his world for every need. The injuries he arrived with were to his head, and they were serious enough that the medical team at the North Shore Hospital made an immediate determination. This child needed a higher level of care than they could provide. He was transferred to a hospital in New Orleans for specialized treatment. Over the next 3 days, physicians and medical staff at the New Orleans hospital worked to sustain the child's life. The injuries were to his brain, the kind of injuries that leave little margin for recovery in a child so young, with a system so small and so newly formed. On March 26, 2022, 3 days after his mother had brought him to that first hospital, the infant did not survive. He was 6 months old. The investigation that followed his passing moved on 2 fronts simultaneously. Medical professionals, as they are trained and legally required to do, communicated their findings and concerns to law enforcement. The injuries this child had sustained were not consistent with an accidental cause. They were consistent with severe, deliberate harm to a very young child, the kind of harm that investigators and medical experts recognize immediately, and that carries its own devastating weight in a courtroom. At the same time, law enforcement was building its case. The circumstances surrounding how the child came to have these injuries, what had occurred in the hours and days before that hospital visit, and what Mejia-Gallo's account of events revealed, or failed to reveal, all became part of the investigative record. Madelyn Abisai Mejia-Gallo was arrested and charged with second-degree murder in connection with the passing of her infant son. The charge reflects the severity of what investigators and prosecutors concluded had occurred, that the actions or omissions that led to this child's injuries were not accidental, that they were not the product of misfortune, but were the result of conduct that the law treats as among the most serious it recognizes. Cases involving infants with severe head injuries occupy a particularly grave place in the criminal justice system. Medical science has developed extensive tools for understanding how these injuries occur, how they differ from accidental trauma, and what patterns of injury are consistent with deliberate harm versus falls or other unintentional events. The medical testimony in cases like this one is often the cornerstone of the prosecution's case, the voice of science speaking for a child who cannot speak for themselves. 6 months old. That is the age at which most children are beginning to develop their first recognizable smiles, beginning to reach for objects, beginning to respond to the voices and faces of the people who care for them. He had barely had the chance to begin. The case against Mejia-Gallo proceeded through the Orleans Parish criminal justice system. The charge of second-degree murder in Louisiana carries the potential for a mandatory sentence of life imprisonment without the possibility of parole upon conviction. The weight of that potential outcome is a measure of how seriously the law treats the loss of a child's life. Cases involving very young children and severe injuries remind every parent, every caregiver, every community member of the extraordinary vulnerability of infants. They are entirely dependent. They cannot report what is being done to them. They cannot call for help. The only system standing between a vulnerable infant and harm is the network of people around them. And when that network fails, the medical and law enforcement professionals who are trained to recognize the signs. In the aftermath of cases like this one, child advocacy professionals consistently point to the importance of early intervention, of home visiting programs for new parents, of support systems that reduce the isolation and stress that can contribute to crisis situations. These are not excuses for what happens in these cases. They are tools that, when properly funded and properly deployed, have been shown to reduce harm to children. This infant's brief life, 6 months, 26 days from birth to the day he did not survive, deserved better from the world around him. What justice requires in cases like his is that every possible investigative avenue is pursued, that the legal process operates with full integrity, and that his memory serves as a call to greater vigilance for children who cannot protect themselves. The community of New Orleans, of the North Shore, of Louisiana, every community that has ever learned about a case like this one, carries a responsibility to keep asking the hard questions. Who saw something? Who could have said something? What systems were in place, and were they functioning? How do we do better for the next child? Those questions do not have easy answers. But the asking of them is not optional when a 6-month-old child loses his life. Accountability, in cases involving the most vulnerable victims, is not just a legal outcome. It is a moral obligation. The courts must do their work with thoroughness and care. And every person who hears this story must carry forward the commitment to look out for children in their own communities. If you or someone you know is concerned about the welfare of a child, contact the Louisiana Child Protective Services Hotline or the Child Help National Child Abuse Hotline at 1-800-422-4453. That call could be the most important one you ever make. Don't forget to like this video and subscribe to Cold Case Hour. Every view and every subscriber helps us continue telling the stories that need to be told, with the seriousness and respect these families deserve. Case 3, Laderika Smith. June 23, 2013. Orleans Parish, Louisiana. There are cases in which a single moment, a single decision, made in an ordinary minute on an ordinary morning, fractures a life irreparably. The case of 5-year-old Mejia-Gallo Smith is one of those cases. It begins with a mother who needed to run an errand, a door that locked behind her, and a gun that should never have been within the reach of a child. It ends with a community asking questions about negligence, about accountability, and about how the law ought to respond when a parent's failure to protect results in a child's death. June 23, 2013. A Sunday morning in New Orleans. The address was on North Galvez Street, a residential block in the city where Laderika Smith, 28 years old, was staying with her daughter. By her own account, and according to the New Orleans Police Department's investigation, Smith left her apartment that morning to make a quick trip to the store. Her daughter, 5-year-old Mejia-Gallo Smith, described by those who knew her as a bright, curious, endlessly questioning child, was left behind. The door was locked. The gun was inside. It belonged to a family friend, Leon Warren, who had been temporarily staying at or keeping belongings at the residence. It was a .38 caliber revolver, fully loaded, and it was not secured. Various accounts from family members described it as having been kept on a high shelf in a closet. But children are curious. Children are capable, and Mejia found it. By the time Laderika Smith returned home from the store, her daughter was lying on the bedroom floor with a wound to her forehead. She had found the revolver, and it had discharged. Smith ran out of the home screaming for help from neighbors. "Lord help me," she cried. "My child is dying." Neighbors heard her. Emergency services were called. Mejia was rushed to a hospital. She was placed on life support. For several hours, medical staff worked to sustain her. By Sunday evening, the effort was not enough. Mejia did not survive. She was 5 years old, and she had barely begun. The investigation that followed moved quickly. The New Orleans Police Department determined that Laderika Smith had left her young daughter alone in a residence where a loaded, unsecured firearm was accessible. Smith was initially booked on a charge of cruelty to a juvenile. When Mejia did not survive, that charge was elevated. A grand jury ultimately returned a second-degree murder indictment against Laderika Smith, a charge carrying a mandatory sentence of life imprisonment in Louisiana. Leon Warren, the owner of the firearm, was also charged in connection with the incident. His responsibility in allowing a loaded, unsecured weapon to be present in a home where a child resided was a central element of the investigation and the prosecutorial theory of the case. The legal proceedings that followed were complex and contested. Orleans Parish Criminal District Court Judge Daryl Derbigny, reviewing the murder charge against Smith, made the unusual decision to override the grand jury indictment, ruling that the law, as written, did not support a second-degree murder charge in these particular circumstances. The Orleans Parish District Attorney, Leon Canitsuro, filed an appeal with the Louisiana Fourth Circuit Court of Appeal, seeking to restore the murder charge. The DA's office was unequivocal in its position. Smith's conduct had been criminally negligent in a way that directly caused her daughter's death. This mother did everything but put the gun in the child's hand, a spokesman for the office stated. The case moved through the courts slowly, as Laderika Smith remained in custody and the appellate process ran its course. Legal experts at the time described the case as raising genuinely difficult questions about how far criminal liability for a parent's negligence should extend, particularly when the child's death results not from a direct act by the parent, but from a failure to protect. Those questions are important. They are not abstractions. They are the kinds of questions that the law must continually revisit as communities grapple with the reality of firearm accessibility and child safety. Studies cited by child injury prevention organizations have consistently found that states with child access prevention laws that hold adults criminally accountable for failing to secure firearms from children, see meaningful reductions in unintentional firearm-related child fatalities. The evidence is clear. Securing firearms prevents children from being harmed by them. Brandagea Smith was a child full of questions, according to those who loved her. She wanted to know things. She wanted to understand the world. She was 5 years old. She deserved the chance to grow up and ask every question she had. The school that Brandagea attended had, according to prosecutors, communicated concerns to her mother about the child in the period before her death, concerns that, investigators argued, gave Smith additional information that should have prompted greater protective action. Whether those communications constituted legally meaningful warning and how they would have been treated as evidence in a trial remained part of the contested record. What is not contested is the loss. A 5-year-old child is gone. A family fractured. A community left to sit with the knowledge that the outcome could have been different, that a single act of securing a firearm would have meant Brandagea walked out of that apartment and grew up. Gun safety advocates, child protective services professionals, and community organizations across New Orleans and Louisiana used this case as a catalyst for renewed conversations about firearm storage laws, about child access prevention, about the obligation of every adult in a child's environment to think carefully about what dangers exist within that environment and what their duty is to address them. The legal process continued to develop through the courts. But the most important legacy of Brandagea Smith's brief life is not found in any courtroom. It is found in the renewed urgency that her story lent to conversations about how we protect children, conversations that must never stop. If there is a firearm in your home, please ensure it is secured with a lock and stored separately from its ammunition. If you are concerned about a child's safety, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Don't forget to like this video and subscribe to Cold Case Hour. These stories matter. These children matter. And the more people who hear them, the louder the call for change becomes. Case 4, Jenée Pedesclaux. August 7, 2022. Orleans Parish, Louisiana. There are cases that a city does not forget. Cases that mark a neighborhood, a street, a morning that should have been ordinary and became something else entirely. The 7th Ward of New Orleans has survived hurricane and flood and generations of hardship. It is a neighborhood with deep roots, with community, with the kind of intergenerational bonds that hold places together. And on the morning of August 7, 2022, it became the location of one of the most devastating tragedies Orleans Parish had seen in years. At approximately 11:17 in the morning, New Orleans Police Department officers responded to an address in the 3100 block of Law Street, a residential street in the 7th Ward, in the area sometimes called the Florida neighborhood. What they found when they arrived was not a crime scene they had been the first to encounter. The children who had been harmed had already been rushed from the location by their father. The perpetrator was still there, or had been moments before, and the story of what had happened and how it had unfolded was already spreading, in real time, across social media. Jenée Pedesclaux was 31 years old on that August morning. She was the mother of 2 children, 4-year-old Parison Roberts and 2-year-old Jacian Roberts. Their father was Jermaine Roberts, and he and Pedesclaux had been engaged in a custody dispute. A hearing was scheduled for August 18th, less than 2 weeks away. The family dynamics were strained. Court documents filed by Roberts in connection with the custody case described his concerns about the children's welfare, about instability in the home, about his inability to see his children. What happened on August 7th began, according to court documents and law enforcement accounts, with a phone call. Pedesclaux contacted Roberts and told him she had caused damage to his vehicle. She then told him she was not going to face any legal consequences for that. and that she would harm herself and the children. Roberts, alarmed, tried to leave for the address. He received a FaceTime call from Pedesclaux. On the call, she showed him their 2-year-old son, Jason, whose neck appeared red and injured. She showed him their 4-year-old daughter, Paris. And then she showed him both children, together. Roberts drove to the address. He found the door locked. He broke a window and forced his way inside. What he found was a scene of devastating injury, both children on a blood-soaked bed. He took them immediately to the University Medical Center of New Orleans, driving them himself, not waiting for an ambulance. Emergency surgical teams received the children and worked to save their lives. Paris and Roberts, 4 years old, did not survive her injuries. She was pronounced dead at approximately 1:40 in the afternoon. Jason Roberts, 2 years old, remained in critical condition for days before beginning to stabilize. Pedesclaux, after Roberts took the children from the home, had injured herself, a superficial wound to her collarbone area that was not considered life-threatening. Paramedics transported her to a hospital for treatment. But before that, she had gone live on social media. The video, which was later deleted from Instagram but was captured and reviewed by investigators, showed Pedesclaux speaking directly to the camera, her clothes marked by the bloodshed, in a state of acute psychological distress. "I'm done," she said. "My children are dead. I'm done with life. It's all Jermaine's fault. It's always Jermaine's fault." That video, and the FaceTime calls preceding it, became central evidence in the investigation. Arrest records reviewed by WWL-TV revealed the sequence of events in detail: the calls, the breaking of the window, the rushed drive to the hospital, the social media broadcast. Pedesclaux was arrested on Sunday, August 7th, and booked into the Orleans Parish Justice Center the following evening. Her charges: second-degree murder, attempted second-degree murder, and 2 counts of second-degree cruelty to a juvenile. In the days that followed, the community responded. Balloons and stuffed animals were placed on the steps of the Law Street home. A pastor from the nearby Law Street Missionary Community Baptist Church, who had been finishing his sermon when the events unfolded, spoke to reporters. "I was hurt," he said. "I came to pray. I've been praying, and I've never stopped praying since I heard what happened." The legal proceedings in this case have been extraordinarily complicated. Within weeks of the arrest, a judge determined that Pedesclaux was temporarily incompetent to stand trial and ordered her transferred to a jail-based mental health facility. An Orleans Parish magistrate made that ruling on August 24, 2022, following evaluations by 4 doctors who interviewed her via video from jail. The doctors reported evidence of a psychotic or mood disorder. She was later found competent and returned to custody. The family of Jenée Pedesclaux spoke publicly about her mental health history, a documented history of psychiatric episodes, prior hospitalizations, a suicide attempt. Her father expressed frustration with the pace of the proceedings and with what he described as inadequate care for his daughter given her condition. "God is trying to tell the judges something," he told the Times-Picayune. "He is the only real judge." By January 2024, the murder case had reached a 3rd Orleans Parish judge, Chief Judge Tracy Flemings Davalier, after 2 previous jurists recused themselves, citing potential conflicts. No trial date had been set as of that reporting. The case remains open. The legal question of criminal responsibility versus severe mental illness is one of the most difficult in the entire criminal justice system. Louisiana law, like the law of most states, recognizes a defense of not guilty by reason of insanity when a defendant was unable, at the time of the act, to distinguish between right and wrong. Pedesclaux's defense team entered that plea. Prosecutors must counter it. The determination will ultimately rest with a judge, based on the testimony of medical experts who will disagree. None of that complexity diminishes what happened to Paris and Roberts. She was 4 years old. She had her whole life ahead of her. She was a little girl who deserved to grow up, to finish that custody hearing, to have a future shaped by the love of a father who broke a window trying to save her. Jason Roberts survived. He was 2 years old. What he carries forward from that August morning is something that no child should ever have to carry. His father, Jermaine Roberts, broke into a locked house for his children that day. That act of desperate love is part of this story too. Mental health systems, child protective services, and the family court system that was processing the custody dispute all intersect in this case. Court documents show that Roberts had already raised concerns about the children's welfare before August 7th. Those concerns were in the system. A hearing was scheduled. The machinery of family law was in motion. And it was not fast enough. In the aftermath of tragedies like this one, mental health advocates consistently argue for earlier intervention, for better coordination between family courts and mental health services, for systems that recognize a parent in crisis before the crisis reaches its endpoint. These arguments are not made to excuse what happened to Paris Roberts. They are made so that the next Paris Roberts has a chance. The 7th Ward neighborhood, the community of New Orleans, and the broader Louisiana public deserve a justice system that moves with appropriate urgency in a case involving the loss of a child's life and the severe harm of another. This case has been moving through the courts for nearly 3 years. Paris and Roberts' family deserves resolution. J.C. Roberts, who survived, deserves to grow up in a world where his sister's case was handled with the full weight of the law behind it. We do not forget Paris. We do not stop asking for accountability. And we hold on to the fact that J.C. is alive, and that the father who drove through his worst nightmare to get his children to a hospital is still here, still fighting for them. Don't forget to like this video and subscribe to Cold Case Hour. These stories are told with the respect and seriousness that these families deserve. Your support keeps this work going. Case 5, The Record Family. April 21st, 2022. East Baton Rouge Parish, Louisiana. There are cases in the record of Louisiana's child welfare tragedies that are almost impossible to comprehend, not because the facts are obscure, but because they are so clear, so straightforward, so undeniable in what they reveal about what a child endured at the hands of the people who were supposed to love and protect her. The case of 4-year-old China Record is one of those cases. And the courtroom conclusion that came in May of 2026, more than 4 years after that April evening in Baton Rouge, sent a signal about accountability that reverberated across the state. China Record was 4 years old. She was living in Baton Rouge, Louisiana, with her family. On the evening of April 21st, 2022, something happened in that household that no child should ever experience. Something that began as an act described by investigators as punishment and ended with China's passing the same night. The central figure in what investigators concluded had occurred was China's grandmother, Roxanne Record. According to the findings of the investigation and the evidence presented in court, Roxanne Record forced the 4-year-old child to consume a substantial quantity of whiskey, approximately half a bottle, as a form of punishment. China's mother, Kaja Record, was present during this event. A 4-year-old child's body cannot process alcohol the way an adult's can. The child's liver, the child's metabolic system, the child's neurological functioning. None of these systems are equipped for alcohol at any quantity, let alone the quantity that investigators determined China had been forced to consume. The medical term for what happened to her is acute alcohol poisoning. It is a condition that is universally recognized as life-threatening in young children at far lower exposure levels than what China experienced. The outcome that evening was not uncertain once the amount consumed was understood. It was, in the assessment of medical professionals, an entirely foreseeable consequence of what was done to her. China Record did not survive that night. Emergency services were called, and medical personnel responded, but the damage to China's small body was too severe. She was 4 years old. The investigation that followed led to the arrest and charging of both Roxanne Record and Kaja Record. Both women faced serious charges in connection with China's death. The presence of Kaja Record, China's own mother, during the event, and her failure to intervene or to prevent what was happening to her daughter, was a central element of the case against her. In Louisiana, as in every jurisdiction, parents hold a legal and moral duty to protect their children from harm. That duty does not pause when the harm is being inflicted by another family member. That duty does not yield to family hierarchy or to deference to an elder relative. The law recognizes no exception for a mother who watches and does not act while her child is being harmed. The legal proceedings moved through the East Baton Rouge Parish court system over the years that followed. The case against Roxanne Record proceeded to trial and, in May of 2026, 4 years and 1 month after China Record's death, Roxanne Record was found guilty of manslaughter. The jury's verdict reflected their determination that Roxanne Record bore criminal responsibility for China's death, that what she had done, whether or not it was intended to cause a fatal outcome, constituted the unlawful taking of a child's life through criminally negligent or reckless conduct. A manslaughter conviction in Louisiana carries potential imprisonment of up to 40 years. The sentencing phase of Roxanne Record's case would determine what consequence she would face for the 4 years of a child's life that were taken on that April evening. The case against Kaja Record, China's mother, proceeded on a parallel track. The specific charges and outcomes for Kaja Record reflect the particular nature of her conduct, her presence, her awareness of what was being done to her daughter, and her failure to intervene or to call for help. Cases like China's force communities and legal systems to grapple with deeply uncomfortable questions about family dynamics, about the ways in which abuse can occur within households where multiple adults are present, about the obligations of bystanders, especially parental bystanders, when a child is being harmed. The law's answer to those questions, in Louisiana and across the country, is increasingly clear. Presence during harm to a child, without protective action, is itself a form of culpable conduct. 4 years old, China Record was a child who should have had decades ahead of her. She should have started school in the fall of 2022. She should have had birthdays and holidays and the ordinary accumulation of experiences that make up a childhood. She deserved protection from the adults in her life. She did not receive it. The verdict in May 2026 did not bring China back. No verdict ever does. But it affirmed, in the clearest possible terms, that what happened to her was not acceptable, that it was not something the law was willing to treat as anything less than what it was, and that the people responsible would be held to account. Louisiana's children deserve caregivers who protect them. They deserve adults who, when they see a child in danger, act, not after the fact, not once the outcome is irreversible, but in the moment when action can still make a difference. China's case is a call to every adult in every household to understand that the obligation to protect a child is not conditional, is not optional, and is not something that anyone in the room can hand off to someone else. We remember China Record. We say her name. And we demand that the system learn from what happened to her. Don't forget to like and subscribe to Cold Case Hour. Your engagement helps these stories reach the people who need to hear them. Case 6. Chelsea Thornton. October 17, 2012. Orleans Parish, Louisiana. The Girt Town neighborhood sits in the 17th ward of New Orleans, bounded by the old streetcar lines and the river, a community with a history as complicated and layered as the city itself. In the fall of 2012, a young mother named Chelsea Thornton lived in an apartment on Audubon Court in Girt Town. She was 23 years old. She had 2 children, 4-year-old Kelsey Adams and 3-year-old Kendall Adams. And she had a documented history of severe mental illness that the people and systems around her had struggled and ultimately failed to adequately address. On the morning of October 17, 2012, Chelsea Thornton checked her children out of their preschool. It was an ordinary act, a mother picking up her children. But the morning that followed was anything but ordinary, and by the time Kelsey and Kendall's paternal grandmother arrived at the Audubon Court apartment that afternoon, both children were dead in the bathtub. What had happened in that apartment on that October morning became the subject of a 5-year legal proceeding, 2 rounds of competency hearings, conflicting testimony from 5 court-appointed mental health professionals, and ultimately one of the most significant rulings in recent Orleans Parish criminal history on the question of criminal responsibility and mental illness. The facts of what occurred are not disputed. Chelsea Thornton, in a taped confession given to NOPD detectives at the former interim LSU hospital on the evening of October 17th, the same day, less than 2 hours after the children were found, described what she had done. Her account, delivered over 18 recorded minutes, was lucid and detailed in its description of events, even as it was irrational in its reasoning. Thornton had taken the children from preschool that morning intending to go to a hospital for a medication refill, she said. She had forgotten her Medicaid card. She brought the children back to the apartment. And then, in the grip of what she described as a need to spare her children from a life like hers, from poverty, from instability, from being passed from pillar to post, she acted. She shot Kendall in the head with a revolver. She then tried to shoot Kelsey. The firearm malfunctioned. Unable to fire again, Thornton filled the bathtub and drowned her daughter. Seeing Kendall still showing signs of life, she submerged him as well. She then changed her clothes, took a bus to the NOPS 1st District Station, intending to turn herself in, and then, losing her resolve, went to meet the children's father, Kenneth Adams, at his aunt's home in the lower Ninth Ward. She eventually ended up at the hospital, asking to be seen for abdominal pain. It was there that investigators, who had already begun searching for her after the children's grandmother found them, made contact. The taped confession was the centerpiece of the prosecution's case. It was also the centerpiece of the defense's case, because defense attorney Lionel "Lon" Burns argued that the very coherence of Thornton's confession was evidence of her detachment from reality rather than proof of her sanity. He argued that only someone steeped in profound psychosis could describe what she had described, and offer the reasoning she offered, and believe she was doing something for her children rather than to them. Orleans Parish prosecutors Tiffany Tucker and Francesca Bridges argued the opposite, that the confession showed Thornton's awareness of her actions and their consequences, that her behavior in the hours after the deaths, the change of clothes, the bus ride, the attempt to turn herself in, the visit to the hospital, demonstrated a functioning understanding of cause and effect, guilt, and consequence. The DA's office presented medical experts who challenged the defense's insanity claim. 5 mental health professionals testified across the competency and trial proceedings. Their conclusions differed. Tulane University forensic psychiatrists Dr. J. Brad McConville and Dr. Sarah DeLand, who evaluated Thornton within days of the events, testified that she had been experiencing a depression-fueled psychotic episode on the day of the children's deaths, that she was suffering from altruistic delusions, a recognized psychiatric phenomenon in which a person believes they are acting in the best interest of those they harm. McConville and DeLand testified that in this state, Thornton was unable to distinguish between right and wrong. State-appointed experts challenged those conclusions. Judge Robin Pittman, who presided over the trial conducted without a jury at Thornton's request, weighed all of this testimony across 5 days of dramatic proceedings. On August 11, 2017, nearly 5 years after the deaths of Kelsey and Kendall Adams, Judge Pittman delivered her verdict, not guilty by reason of insanity on both counts of first-degree murder. The courtroom erupted. Thornton's family members, who had packed the gallery, gasped and wept. The children's paternal grandmother, the woman who had discovered them in that bathtub, who had lived with that image for 5 years, was in the courtroom. The DA's office expressed deep disappointment and concern about the court's ability to mandate hospitalization going forward. Christopher Bowman, the DA's spokesman, said the office was very concerned about what the verdict meant for public safety. Judge Pittman, following the not guilty ruling, immediately ordered a dangerousness hearing to determine whether Thornton would be confined or released. In December 2017, Pittman ruled Thornton a danger to herself and others and committed her to the Eastern Louisiana Mental Health System, a state psychiatric facility, for treatment. She would spend the next 3 years there. In November 2020, following extensive legal proceedings and a Zoom hearing conducted during the pandemic, Judge Pittman granted Chelsea Thornton conditional release to a group home in Baton Rouge described as a dorm-like setting. Thornton's release was conditional on strict supervision, medication compliance, and regular check-ins. Her defense attorney called it a moment of grace. The DA's office maintained its concerns. Kelsey Adams was 4 years old. Kendall Adams was 3 years old. They were taken from their preschool on an October morning by their mother, and they never went back. Their grandmother found them. Their father's family bore a loss that no family should ever have to bear. And the preschool where they had been students, the neighbors on Audubon Court, the community of Gert Town, all of them carry the memory. This case raises questions that have no easy answers about the obligations of a mental health system to intervene before a crisis becomes a tragedy, about the gap between a parent who is struggling and the services that might have stabilized her, about what not guilty by reason of insanity means for justice and for the families of victims. These questions do not resolve easily. They live in the law, in medical ethics, in community advocacy. They demand that we keep asking them. Chelsea Thornton's mother, Eleanor Chapman, testified at trial about her daughter's deteriorating mental state in the months before October 2012, about warning signs she saw, about her own regret that she had not acted more forcefully to have her daughter committed again. "That's the biggest regret I have in my life," she told the prosecutor on cross-examination. A mother who saw her daughter slipping and could not stop it. A grandmother who found her grandchildren and could not undo it. Kelsey, Kendall, they are not forgotten. Don't forget to like and subscribe to Cold Case Hour. Your support means everything as we continue telling these stories with the dignity and care they deserve. Case 7, Hannah Faith Cormier. August 13th, 2024. Jeff Davis Parish, Louisiana. On a Tuesday morning in August of 2024, in the small city of Jennings, Louisiana, approximately 90 miles southwest of Baton Rouge, a 10-month-old baby girl was buckled into a car seat in the back of her mother's vehicle. Her mother, Hannah Faith Cormier, 32 years old, drove to work that morning. She worked at a Wendy's restaurant in Jennings. She went inside, and her daughter was still in the car. Outside, the heat index that morning exceeded 106 degrees Fahrenheit. Inside a vehicle parked in a Louisiana summer, a sealed, airless space that functions like an oven in direct sunlight, temperatures reached between 140 and 150 degrees. That is not a figure that requires medical expertise to understand. At 140 degrees, the interior of a parked vehicle in August is not a space where any living creature can survive. A 10-month-old child, whose body temperature regulation systems are among the least developed of any living human, has almost no margin. Hannah Cormier worked her shift. Cormier's work records, reviewed by investigators, indicated she was inside the restaurant for approximately 2 hours. At some point during or after that shift, she went to her vehicle and found her daughter. She brought the child to a local hospital in Jennings at around 4 in the afternoon. She told hospital staff that the baby had been in the car for about an hour and a half. Medical personnel who received the child took immediate action, but the damage was catastrophic. The infant's body temperature was measured at 109 degrees Fahrenheit at the hospital. Staff worked to obtain a pulse. The following night, August 14th, the child did not survive. She was 10 months old. The Jennings Police Department opened a criminal investigation. Chief Danny Sims stated publicly that investigators believe Cormier had intentionally taken the child to work and left her in the hot car, not with the intent to do harm to the child, but by her actions, harm was caused. That framing, not an intent to harm, but conduct whose consequences were entirely foreseeable, captures the legal and moral core of what followed. On August 18, 2024, Hannah Faith Cormier was arrested and charged with second-degree murder and cruelty to a juvenile. Her bond was set at $1 million. The charges reflected the gravity of the investigation's conclusions, that leaving a 10-month-old child in a vehicle under those conditions, for that duration, in that heat, was conduct that the law would treat with the utmost seriousness. On October 2, 2024, a Jeff Davis Parish grand jury reviewed the evidence and returned an indictment, not for second-degree murder, but for negligent homicide. Negligent homicide in Louisiana is defined as the taking of a human life by criminal negligence, conduct that falls significantly below the standard of care that a reasonable person would exercise in the same circumstances, resulting in death. The grand jury's decision to indict on that charge rather than the more serious murder charge reflected their assessment of the intent question. The case proceeded. On July 14, 2025, nearly a year after the indictment, Hannah Faith Cormier entered a plea of no contest to the negligent homicide charge. A no contest plea is legally equivalent to a guilty plea in terms of its effect on sentencing, but it does not constitute an admission of guilt in the formal sense. A sentencing date was set. On January 21, 2026, Hannah Faith Cormier appeared before Judge Steve Gunnell in Jeff Davis Parish for sentencing. The state, represented by Assistant District Attorney Tori Thibodeau, sought a sentence in the range of 5 to 10 years. The defense, represented by Attorney Bill Riley, presented mitigating circumstances, Cormier's illness on the day in question, the claimed confusion about her work schedule, positive steps she had taken since the incident, including parenting and mental health counseling, and the regaining of custody of her 4 other children. Judge Gunnell sentenced Hannah Faith Cormier to 5 years of hard labor, without benefit of probation, parole, or suspension of sentence. The enhanced penalty applied because the victim was under the age of 10 years. Louisiana law mandates hard labor imprisonment in such cases, without the possibility of early release through the usual mechanisms. District Attorney Lauren Heinen issued a statement after the sentencing. "The death of any child is heartbreaking," she said. and losing this 10-month-old baby has deeply affected our whole community. No sentence can bring her back or take away the pain everyone feels. This was a difficult case with tragic circumstances, but every child deserves to be protected. Every child deserves to be protected. That statement is simple and it is absolute. Hot car deaths are among the most preventable child fatalities that occur in the United States. Safety advocates consistently promote the same core messages. Never leave a child unattended in a vehicle, even for a minute. Always check the back seat before locking the car. Leave a visual reminder, a shoe, a bag, a phone, in the back seat when a child is being transported, so that the act of reaching for that item breaks any routine that might otherwise result in a child being forgotten. The science of how these tragedies happen is well understood. The prevention strategies are simple, and yet children continue to lose their lives in hot vehicles every summer. The 10-month-old daughter of Hannah Faith Cormier did not have a voice. She could not knock on a window or call for help or communicate her distress in a way that would have been heard. She was 10 months old. She was entirely dependent on the adult who had brought her into that vehicle to remember she was there and to take her out. The community of Jennings and the broader community of Southwest Louisiana mourned this child. The legal system processed her case and delivered a sentence. And the advocates and educators who work on child safety in vehicles continue to work, year after year, to ensure that no other community has to go through what Jennings went through in August of 2024. If you are a parent or caregiver, please take a moment right now to learn about the Look Before You Lock campaign and other child vehicle safety resources. This information is available through the National Highway Traffic Safety Administration at nhtsa.gov. Don't forget to like and subscribe to Cold Case Hour. We are committed to responsible, respectful documentary storytelling, and your support makes it possible. Case 8, Hilda Vasquez. August 14, 2025. Orleans Parish, Louisiana. New Orleans East is a sprawling section of the city east of the Industrial Canal, a largely residential area, a community of neighborhoods, of families, of people who have rebuilt and continued and persisted through everything the city has thrown at them. The Village de l'Est neighborhood, known informally as Versailles for its large Vietnamese-American community, sits near the eastern edge of the city, close to the wetlands and waterways that define this part of Louisiana's geography. It was on Beaucaire Street in this neighborhood that 12-year-old Brian Vasquez disappeared in the early morning hours of August 14, 2025. Brian Vasquez had been a victim of abuse and neglect not for months, but for his entire 12 years of life. When he was 3 months old, his mother had called an ambulance claiming the baby had stopped breathing. When Brian arrived at the emergency room, he had injuries that went far beyond any respiratory episode: a skull fracture, broken legs that caused his ankles to bend outward, a damaged lung, retinal hemorrhages. A doctor who reviewed his injuries described them as acute and suspicious of non-accidental trauma. Hilda Vasquez, then around 22 years old, was charged in 2014 with cruelty to juveniles and second-degree cruelty to juveniles. She later pleaded guilty to a reduced charge of negligent treatment or neglect. Brian was placed in foster care. He was later returned to his mother's care. The abuse did not stop. In 2021, Brian's school reported concerns to the Louisiana Department of Children and Family Services. The DCFS report that followed documented bruises on Brian's face and inner thigh. It also documented something else. On 2 separate occasions, Brian had had tapeworms. His individualized education plan at school listed his disability not as autism, as the family had described him, but as a traumatic brain injury, specifically, a traumatic brain injury categorized as non-accidental. The injury that had defined Brian's developmental limitations for his entire life had been caused deliberately. Brian's mother had told police that he was autistic. The DCFS records indicated his condition was the result of abuse inflicted on him as an infant. Despite all of this, the 2014 conviction, the 2021 DCFS report, the documented pattern of harm, Brian Vasquez had remained in the custody of Hilda Vasquez. He had been removed and returned. The system had touched his case and moved on. And in the early morning hours of August 14, 2025, a bedroom window was left unsecured, and Brian walked through it and toward a lagoon, and he did not come back. NOPD Deputy Superintendent Nicholas Jernon addressed the press directly and without euphemism. It was not this tragic event that occurred in August that led to these charges, he said. It was a pattern of abuse and neglect that occurred throughout his entire 12 years of life. Hilda Vasquez, 34 years old, was arrested on September 7, 2025. She was booked into the Orleans Parish jail on charges of second-degree cruelty to juveniles and negligent homicide. She appeared in magistrate court the following Monday, speaking through a Spanish-language interpreter. She said she would hire a private attorney. Friends, supporters, and search volunteers held a memorial walk and placed a marker for Brian Vasquez in New Orleans East on August 28, 2025, 2 days after his body was found, while the grief of the search was still raw. Hundreds of people who had never met Brian came to walk for him, to say his name, to stand in the neighborhood where he had lived and acknowledge that his life had mattered. The systemic failures in Brian's case, the return to an abusive home, the inadequate follow-through after documented abuse, the gaps in the missing persons alert system, prompted the New Orleans City Council's action and sparked statewide conversations about child welfare oversight, about how DCFS manages cases involving children with disabilities, and about the obligations of schools and medical providers who document abuse to ensure that the information reaches the people and systems that can act on it. Brian Vasquez deserved a safe home, a secured window, an adult who checked on him in the night, a system that stayed engaged after the first documented injury, and a community that knew he was missing immediately when he walked through that window. He deserved all of these things. He received none of them. His name is Brian Vasquez. He was 12 years old. He is remembered. Don't forget to like and subscribe to Cold Case Hour. Brian's story, and stories like his, deserve to be heard. Thank you for being part of this community. Case 9, Makayla Ryan. August 2024. Orleans Parish, Louisiana. Not every case in the criminal record of child harm involves a child whose fate is immediately known. Some cases begin with a story that a woman tells to police, a story that draws in investigators and resources and the attention of a community, and only later, as the investigation deepens and the story begins to unravel, does the true shape of what happened come into focus. The case of Makayla Ryan, which began in August of 2024 in New Orleans East, is one of those cases. And while the full depth of what occurred is still being processed through the legal system, what is already known is troubling enough to demand a serious examination. In August of 2024, Makayla Ryan contacted law enforcement in New Orleans East with what she described as a discovery. She had found a baby, she said, abandoned in a car seat. The call presented itself as an act of civic responsibility. A woman who had come across a helpless infant and done the right thing by immediately alerting the authorities. The image it conjured was of an innocent bystander, of a found child, of a mystery to be solved. The New Orleans Police Department, responding to the report, began investigating. Investigators assigned to the case worked through the details of Ryan's account, where she had been, when she had found the baby, what circumstances had led her to the location, what she knew about the child or the child's identity. New Orleans East is a community that, like all communities, takes seriously any report involving a child's safety. Resources were allocated. The investigation moved forward. But as investigators dug deeper into the particulars of Ryan's account, inconsistencies began to emerge. The details she provided, when measured against the physical evidence, against witness accounts, against the timeline she described, did not hold together in the way that a truthful account should. The gap between what Ryan was saying and what the evidence showed grew wider as the investigation progressed. What investigators ultimately concluded was that Makayla Ryan had not found an abandoned baby at all. She had fabricated the report. She had constructed a story of discovery and reported it to law enforcement as fact, and the reason she had constructed that story, the purpose the false report was designed to serve, was to conceal her own connection to and involvement with the child's care. The nature and extent of that concealment, and what it was specifically designed to hide, were the subjects of the criminal investigation that led to Ryan's arrest. She was charged with filing a false police report, a charge that reflects the law's recognition that deliberately misleading law enforcement, particularly in matters involving child welfare, is a serious offense that diverts critical investigative resources and potentially places a child at greater risk. false reports involving children are treated with particular gravity by law enforcement and prosecutors. When someone manufactures a story about a found or abandoned child, they trigger a response that draws on significant public resources, patrol officers, detectives, child protective services workers, potentially medical personnel. More importantly, the false narrative they create can actively interfere with the ability of investigators to understand what is actually happening to a child and to take appropriate protective action. The circumstances that led Makayla Ryan to craft this particular false narrative, what she was trying to hide, what the true situation with the child was, and what the outcome of that situation ultimately was, represent the core of what investigators were seeking to establish in the criminal case against her. Cases like this one serve as reminders that child welfare investigations depend entirely on accurate information. When a child is in an unsafe situation, the ability of the systems designed to protect that child, child protective services, law enforcement, the courts, to function depends on people providing truthful, complete accounts of what they know. When someone deliberately provides false information, whether to protect themselves from legal consequences or to manage a situation they cannot control through legitimate means, children can be placed at greater risk, and the systems designed to protect them can be made to work against them. New Orleans East has seen more than its share of cases involving children in difficult circumstances. The community, parents, neighbors, faith leaders, schools, has consistently responded to these cases with a call for greater accountability, for better systems, for the kinds of early intervention and support structures that can address family crises before they become tragedies. The legal proceedings in Makayla Ryan's case represent one piece of that accountability. The charge of filing a false police report carries consequences under Louisiana law, and the investigation into the full circumstances of what happened to the child involved was part of the ongoing work of the NOPD and child welfare authorities in Orleans Parish. Every child in New Orleans East, and in every neighborhood of this city, deserves to be seen honestly, to be represented truthfully to the authorities whose job it is to protect them, and to have the adults in their lives take responsibility for their care rather than constructing stories designed to deflect that responsibility. The work of holding people accountable for dishonesty in child welfare contexts is not glamorous. It does not generate the kind of headlines that more dramatic cases do. But it is essential work, because the integrity of the child protection system depends entirely on the honesty of the people who interact with it. When that honesty is absent, children fall through the cracks. And in a city that has seen what falling through the cracks looks like for its most vulnerable residents, that is not an acceptable outcome. We watch this case. We follow the proceedings. And we hold to the principle that every child in New Orleans deserves the full, honest, and engaged protection of every adult in their life. Don't forget to like and subscribe to Cold Case Hour. Your support helps us continue shining a light on the cases that matter. Case 10, Raynisa Young and Marlon Perrilloux. January 1st, 2026. Ascension Parish, Louisiana. New Year's Day, 2026. Across Louisiana and across the country, families were welcoming the arrival of a new year, with celebrations, with gatherings, with the ordinary rituals of beginning. In Geismar, a community in Ascension Parish situated along the Mississippi River south of Baton Rouge, the new year began differently. It began with a phone call for emergency services, with a father carrying an unresponsive child to a vehicle, with sheriff's deputies meeting a man at a gas station on Highway 73 at approximately 9:30 in the evening, and beginning CPR on a small boy in the back seat of a car. The boy's name was Marlon Perrilloux. He was 5 years old. By 9:44 that evening, less than 15 minutes after the deputies encountered him, Marlon was pronounced dead at the hospital. He weighed 19 pounds. He measured 35 inches in length. He fit into a body bag sized for infants. He was 5 years old. The Ascension Parish Sheriff's Office, responding to what had been reported as a medical emergency, found at the gas station on Highway 73 not a family in a moment of unexpected crisis, but, as the investigation that followed would reveal, the end point of a tragedy that had been building, slowly and invisibly, for years. The visible signs on Marley's body were not those of a sudden illness. They were the signs of prolonged, catastrophic neglect, a distended abdomen, extremely low muscle mass in his arms and legs, physical deformities in his left arm, and left leg consistent with past injuries that had healed without medical treatment. Hospital staff, receiving Marley that night, reported their findings to law enforcement immediately. Signs of severe malnourishment. Weight of 19 pounds at age 5. The characteristics of profound, extended nutritional deprivation, not a day or a week, but months or longer of inadequate food. They also noted that his remains were so small that the body bag typically used for children his age was too large. Infant-sized. A 5-year-old child in an infant body bag. Investigators secured a search warrant for the family's residence on Anderson Road in Geismar. What they found inside was described by the Ascension Parish Sheriff's Office in terms that were difficult to process. A home in conditions severe enough to be compared publicly to an episode of the television program Hoarders, with old food and trash throughout. The home was, in the words of investigators, barely livable. Deputies noted that it appeared Marley had been spending most of his time confined to a small section of a couch. He was bedridden, according to investigators, and had apparently rarely, if ever, left the residence. His father, Marlon Perrilloux, 33 years old, had been the parent who drove him to the gas station that night. His mother, Raynisa Young, 27 years old, was interviewed at the scene. During that interview, she made what arrest documents described as several concerning statements about how her son had been cared for. Among the details that emerged from her account, the last time she recalled giving Marley a bath was around Thanksgiving, approximately 5 weeks before he died on New Year's Day. 5 weeks without a bath. 19 pounds at age 5. A home barely livable. A body bag for an infant. Ascension Parish Sheriff's Colonel Donald Capello spoke about the case publicly and without hedging. This is probably the worst case of child neglect I have seen in my 34 years of law enforcement, he said. Marlon Perrilloux and Raynisa Young were arrested on January 2, 2026, the day after Marley's death, and charged with negligent homicide, second-degree cruelty to juveniles, possession with intent to distribute a Schedule I narcotic, possession of drug paraphernalia, and illegal carrying of a weapon. The drug and weapon charges reflected what investigators had found during the search of the residence. Evidence of controlled substance activity and an illegally possessed firearm in the home where Marley had been confined. 3 other children were living in the home. They were taken into the protective custody of the State Child Protection Agency. The legal case moved quickly. On February 2, 2026, a grand jury in Ascension Parish returned indictments against both Perrilloux and Young, upgrading the charges to second-degree murder. The grand jury's determination that the evidence supported a charge of second-degree murder rather than negligent homicide reflected their assessment that the conduct of these parents went beyond negligence into the category of an intentional act that the law regards with the maximum severity. On February 9, 2026, Marlon Perrilloux and Raynisa Young appeared before an Ascension Parish judge for arraignment. Both pleaded not guilty to the second-degree murder charge and the associated charges. Both were denied bond. They remain in the Ascension Parish jail. What emerged in the days and weeks following the arrest added another layer of devastating context. State child protection officials acknowledged that the Louisiana Department of Children and Family Services had received prior complaints, not about Marley specifically, but about his older siblings, who had reportedly arrived at school unkempt. Those complaints had not, according to the DCFS, risen to the level that prompted a home visit. No one from the agency had visited the residence where Marley was living. No one had seen him. No one had checked. Louisiana lawmakers on the Task Force on Child Abuse Investigations, meeting after the case became public, expressed outrage, not only at the conduct of the parents, but at the systemic failure that had allowed Marley to exist in those conditions without any intervention. Senator Regina Barrow, head of the task force, said she was very alarmed, and that the fact that Marley had never been seen by any authorities was a complete failure of the system. Complete failure. A 5-year-old child who weighed 19 pounds, who fit in an infant body bag, who had apparently never left his home in any meaningful way, who existed in a house described as barely livable with drug activity and weapons, who had not been bathed in weeks, and no one in any official system had ever looked at him. The system that exists to protect children like Marley, the Child Protective Services infrastructure, the school reporting system, the law enforcement structures, depends on connectivity and follow-through. A complaint about unkempt older siblings should have prompted a visit. A visit would have revealed what was happening to Marley. What was happening to Marley, once revealed, could not have been overlooked. Those failures are being examined. Legislators are pursuing changes to ensure notification and oversight. The DCFS is being pressed to explain and reform its processes. The work of accountability in this case is not limited to the courtroom where Perrilloux and Young faced the consequences of their conduct. It extends to every level of the system that should have seen Marley and did not. Marley Perrilloux was 5 years old. He was 35 inches tall. He weighed 19 pounds. He fit in a body bag for an infant. He deserved every meal he was denied. He deserved every bath he did not receive. He deserved the chance to leave his house and see the world that exists outside it. He deserved to turn 6 years old. His 3 siblings, who survived, are now in the care of the state. They are alive. And the community of Ascension Parish, of Louisiana, of every person who hears this story, now carries the responsibility of demanding that the system learn from what it failed to see, and that Marley Perrilloux is the last child who falls through the cracks in this way. His parents face the most serious charge the Louisiana Criminal Code provides for. The courts will do their work. The law will render its judgment. And we will remember Marley. We say his name. We refuse to let this story be reduced to a statistic. If you or someone you know is concerned about a child's safety, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Available 24 hours a day, 7 days a week, with trained crisis counselors ready to help. You do not need to be certain that abuse is occurring to make that call. If something feels wrong, please call. Don't forget to like this video and subscribe to Cold Case Hour. Every like, every comment, every share helps YouTube understand that this kind of serious, responsible true crime documentary deserves to reach the widest possible audience. We are committed to telling these stories with accuracy, dignity, and an unwavering commitment to the victims at the center of every one of them. Thank you for watching Cold Case Hour. These stories are hard. They are meant to be hard. Because the children at the center of them were real, and their lives mattered, and the communities that lost them deserve to know that someone is still paying attention. We'll see you in the next one.